Rule 81. Bond of Executors and Administrators. Section 1. Bonds to be given before issuance of letters. Amount. Conditions. Before an executor or administrator enters upon the execution of his trust, and letters testamentary or administration issue, he shall give a bond, in such sum as the court directs, conditioned as follows. A. To make and return to the court, within 3 months, a true and complete inventory of all goods, chattels, rights, credits, and estate of the deceased which shall come to his possession or knowledge or to the possession of any other person for him. B. To administer according to these rules, and, if an executor, according to the will of the testator, all goods, chattels, rights, credits, and estate which shall at any time come to his possession or to the possession of any other person for him, and from the proceeds to pay and discharge all debts, legacies, and charges on the same, or such dividends thereon as shall be decreed by the court. C. To render a true and just account of his administration to the court within 1 years, and at any other time when required by the court. D. To perform all orders of the court by him to be performed. Section 2. Bond of executor where directed in will. When further bond required, if the testator in his will directs that the executors serve without bond, on with only his individual bond, he may be allowed by the court to give bond in such sum and with such surety as the court approves, conditioned only to pay the debts of the testator, but the court may require of the executor a further bond in case of a change in his circumstance, or for other sufficient case, with the conditions named in the last preceding section. Section 3. Bonds of joint executors and administrators. When 2 or more persons are appointed executors or administrators, the court may take a separate bond from each, or a joint bond from all. Section 4. Bond of special administrator. A special administrator before entering upon the duties of his trust shall give a bond, in such sum as the court directs, conditioned that he will make and return a true inventory of the goods, chattels, rights, credits, and estate of the deceased which come to his possession or knowledge, and that he will truly account for such as are received by him when required by the court, and will deliver the same to the person appointed executor or administrator, or to such other person as may be authorized to receive them. Rule 83. Inventory and Appraisal. Provision for support of family. Section 1. Inventory and appraisal to be returned within 3 months. Within 3 months after his appointment, every executor or administrator shall return to the court a true inventory and appraisal of all real and personal estate of the deceased which has come into his possession or knowledge. In the appraisement of such estate, the court may order 1 or more of the inheritance tax appraisers to give his or their assistance. Section 2. Certain article not to be inventoried. The wearing apparel of the surviving husband or wife and minor children, the marriage bed and bedding, and such provisions and other articles as will necessarily be consumed in the subsistence of the family of the deceased, under the direction of the court, shall not be considered as assets, nor administered as such, and shall not be included in the inventory. Section 3. Allowance to widow and family. The widow and minor or incapacitated children of a deceased person, during the settlement of the estate, shall receive therefrom, under the direction of the court, such allowance as are provided by law. Rule 84. General powers and duties of administrator. Section 1. Executor or administrator to have access to partnership, books and property. How right enforced. The executor or administrator of the estate of a deceased partner shall at all times have access to, and may examine and take copies of, books and papers relating to the partnership business, and examine and make invoices of the property belonging to such partnership, and the surviving partner or partners, on request, shall exhibit to him all such books, papers, and property in their hands or control. On the written application of such executor or administrator, the court having jurisdiction of the estate may order any such surviving partner or partners to freely permit the exercise of the rights, and to exhibit the books, papers, and property, as in this section provided, and may punish any partner failing to do so for contempt. Section 2. Executor or administrator to keep buildings in repair. An executor or administrator shall maintain in tenantable repair the houses and other structures and fences belonging to the estate, and deliver the same in such repair to the heirs or devisees when directed so to do by the court. Section 3. Executor or administrator to retain whole estate to pay debts, and to administer estate not willed. An executor or administrator shall have the right to the possession and management of the real as well as the personal estate of the deceased so long as it is necessary for the payment of the debts and the expenses of administration.